Welcome to Criminal Law and Procedure. In this seminar, we're going to cover all of the major issues from both of these very important topics. If you're doing these seminars in the order that I suggest, you will be doing this second after having looked at torts. Now, all of these exercises are self-contained. There's no need to follow the order that I prescribe. But torts is a good subject to begin with because it offers us such a broad landscape of both theories of liability and remedies. Criminal law is a good subject to do next because the same basic approaches that apply to torts also apply to crimes. In both torts and criminal law, the plaintiff has to have one or more theories of liability against the defendant. Now, obviously, in torts, we've got a civil plaintiff that only has, generally speaking, that only has to show a preponderance of the evidence. In criminal law, the plaintiff is the prosecutor, and the prosecutor has to establish each element of each charged offense beyond a reasonable doubt. So, the standard of proof is higher in criminal court, but the basic intellectual job, both for the lawyers and on the bar exam and in law school exams, is connect the facts of what happened with elements of the various theories of liability and see whether or not it adds up to a finding of guilt. Now, in criminal law, just as in torts, the defendant is likely to have a number of defenses to the theory of liability. And, of course, we will focus as broadly as possible on as many defenses as the defendant might reasonably bring up, and we will narrowly and specifically, again, analyze the facts to determine whether or not the defendant has a strong defense or not. Another similarity between torts and criminal law is, in both of these topics, we spend a fair amount of time focusing on the defendant's mental state. And this is an even more important part of crimes than it is in torts. And we will see in criminal law that the mental state of the defendant is relevant, and we will also see that some of these issues can get fairly complicated. My approach is to focus on the various mental states in line with each of the various crimes. Now, a more scholarly approach to this material will have an entirely separate section on the mental state of the defendant. And although I respect that approach, I don't think it's very practical, because as we think about how this material is tested, and more importantly, where the points are, I think it is far more appropriate to focus our attention on the elements of the various theories of liability and to appreciate the relevance of the defendant's mental state as it lines up with each one of the crimes. To get into a great deal more than that strikes me as studying psychology rather than studying law. So, criminal law is very much like torts. There are various theories of liability, all of which you need to know. Each one of these theories of liability consists of elements, each one of which you need to know. For essay purposes, we break up each issue into the elements, and then we connect the facts. On the multi-state bar exam, the examiners can focus your attention individually on each of the elements or on multiple elements simultaneously. And as you'll see, one of the best ways, probably the best way, to learn the fine points of law is by doing as high a volume of multi-state practice as possible, and also doing a fairly high amount of essay practice. And here, as always, I present outlines that are reasonably detailed, but that hardly can be considered rigorous. As you get into practice, and as you identify details that are not present on the outline, I advise you to annotate the outline, thereby becoming a more active learner, and also it will help you to focus your attention on whether or not the material that you're not sharp on is really important or not. So, if criminal law is very similar to torts, criminal procedure is our introduction to constitutional law. And we'll also see criminal procedure is intrinsically connected with evidence. In criminal procedure, what we're focusing on is the defense, and the defendant will offer objections principally arising out of the 4th, 5th, and 6th Amendments to the United States Constitution. And what the defendant's constitutional objections can result in is the exclusion of evidence. And typically, the evidence that is being excluded is highly probative of the defendant's guilt. So, The exclusionary rule is the core of criminal procedure, but it's not all of criminal procedure. We will see that there are plenty of non-exclusionary rule issues as well, and that these relate principally to the Sixth and Eighth Amendments to the United States Constitution. And again, we're taking a broad overview here, and we're not getting into the really tiny fine-line distinctions. But having the picture in broad strokes is enormously useful. In criminal law, we're establishing liability. In criminal procedure, the defendant is imposing or is interposing constitutional objections to certain items of evidence or to the way that the government has chosen to prosecute the defendant. The issues here are comparatively straightforward, and they are tested in a fairly ritualistic fashion. And I think it is safe to say, really across the country, that criminal law is more important on the multi-state, and criminal procedure is somewhat more heavily tested on the essays. That's a broad generalization, and individual jurisdictions can differ. But generally speaking, it's true. On the multi-state bar examination, there are 33 questions on criminal law and procedure. Roughly 20 of these questions will deal with criminal law, and that leaves roughly 13 questions to deal with the entire body of law from criminal procedure. So to give you an idea about how to prioritize, the entire body of law from criminal procedure is roughly as important as the law of negligence, or roughly as important as the law of hearsay. So there's a great deal of material in criminal procedure. But in relative terms, it's not that important, and having a clear understanding of all of the high points and a reasonable glib familiarity with everything else is pretty much all you need. And the best way to master the details of criminal law and procedure is by doing a high volume of practice. Now, the approach that we're going to follow in this series of videos is very straightforward, and although it does not exactly track with the National Conference of Bar Examiners outlines, I think you'll see that the decisions that I've made editorially are very sensible and that they streamline the material well. The very first thing that we're going to cover in these seminars is crimes to the person. Crimes to the person. And the most important of these by a wide margin is homicide. So in crimes to the person, it'll basically break down to homicide and then everything else. And we'll spend a reasonable amount of time focusing on those details. But you will hear echoes from the law of torts, because essentially what we'll be doing is rehearsing elements of the theories of liability and addressing the most commonly tested issues within each of those elements. After we finish crimes to the person, we will focus on crimes to property. And here again, you can hear echoes of our approach to torts, because back in the law of torts, we focused on torts against the body and torts against property. And here in criminal law, we're doing exactly the same thing again. With regard to crimes against property, this breaks down into, basically, theft and everything else. And we'll see that the theft crimes actually are fairly complicated. Once again, it's easy to get bogged down. I'm going to try to direct your attention to the approach to the material that will help you avoid that problem. After we're done with crimes to people and crimes to property, then we focus on the inchoate offenses. And a lot of outlines take this material first, because really the preliminary offenses do intellectually precede the basic crimes to people and property. But I think the better approach is to prioritize the material based on how important it is on the exam. Homicide is by far the most important crime, and the other crimes to people and to property naturally follow the law of homicide. So the crimes to property, again, very straightforward and like torts. The inchoate offenses, which include attempt and conspiracy, conspiracy, attempt, and solicitation. Solicitation's the one that I had trouble getting on the tip of my tongue. These all are quite straightforward, and although there's plenty of room to get tripped up in them, we'll take a look at them after we look at the crimes to people and the crimes to property. Next, we will have a separate video just on defenses. And here I've made another decision, which is to have a separate section on defenses. Although I will discuss defenses in line with the various crimes, I do think it's important to focus on the defenses separately, and so that's what we'll do. After that, we will turn our attention to criminal procedure, and there we will focus on the exclusionary rule first, dealing with the Fourth, Fifth, and Sixth Amendments, and then we'll focus on the non-exclusionary rule issues which arise principally from the Sixth and Eighth Amendments. And then after that, we will have a series of 6 videos, each of which corresponds to a legal hypothetical. And as you take a look back after you make your way through all 6 of the hypotheticals, you'll see that I've done a reasonably good job at covering much of the outline of criminal law and procedure. And we'll see that these hypotheticals focus our attention both on crimes and on criminal procedure, sometimes in the same fact pattern. And this is analogous to how many states approach it on the essays, and also to how the National Conference of Bar Examiners deals with the material, both on the multi-state bar exam and also on the multi-state essay exam. Once again, I advise you to make this as active an experience as possible. When you get to the hypotheticals, I would advise you to go over each individual hypothetical by yourself on your own before you turn on the video and watch my discussion of the issues presented. The idea here is to make practice the backbone of your approach to this material. As you notice that you are not very good at certain issues or sub-issues, that's when you should annotate your outline to make sure that you reinforce this knowledge, and also to keep a perspective on how important the issue is. If you are making mistakes with regard to a tiny issue with regard to solicitation, that's a lot less important than if you don't understand the fundamentals of self-defense. So I encourage you to be as active as possible in your use of the materials. And by the time you're done, you will have found that you have completed a comprehensive review of all of the most important issues, both from criminal law and criminal procedure.